Welcome to Small Practice Support Information Session number 49. In this Law Society of Ireland recording, Dr. Brian Doherty and Pádraig Langan of the Legal Services Regulatory Authority talk to Keith O'Malley about limited liability partnerships. Welcome to the latest, I think it's number 48, Small Practice Support Information Session. We're very fortunate to be joined by Dr. Brian Doherty, Chief Executive of the Legal Services Regulatory Authority, and Pádraig Langan, who is head of the title, there's Head of Registration, Levy and Fees Unit. He's been in that role for the last 3 years, since 2018. Pádraig is an expert on the whole area of limited liability partnerships, and we look forward to hearing from him on that. But we're starting with Dr. Doherty, who's going to talk us through the role of the LSRA and the way that's changing and developing over time. And Dr. Doherty has an incredibly interesting background himself. He was called to the bar in, I think, 1996 in Belfast, and for about the following 20 years, he practiced between he spent time in Northern Ireland Police Commission and also in the Garda Síochána Commission, and he's took up the role as Chief Executive of the Legal Services Regulatory about 4 years ago. And I'm going to hand over now to you, Brian, and please tell me when you want me to put up slides, if you would.
Thank you, Keith, and thank you to the Law Society and the Small Practice Support team for allowing myself and Pádraig to come and talk to you today. I'm going to speak to you a little bit about the role of the LSRA, but we're going to focus primarily on limited liability partnerships. So I'll give you an overview how that fits in with the work of the LSRA, and then I'll hand you over to my colleague Pádraig, who is, Keith said, Pádraig is our registrar. He works in the Levy, Registration and Fees Unit, and has responsibility not only for the register of LLPs, which we'll cover in some detail, but also for the role of practicing barristers and for issuing the levy. So as I said, I'm going to give you some context around the LSRA, talk you through our work on limited liability partnerships. I'll introduce the basic features of limited liability partnerships, the obligations that flow to partners once they are authorised, and some of the limits of limited liability. Pádraig then will talk you through the application process, which is meant to be as simple and as straightforward as possible, because one of the things in the Act, the 2015 Act around LLPs, is that it's meant to be a permissive system. It is meant to encourage applications, and the application process is relatively straightforward. We will, if possible, take questions if we can towards the end. Keith mentioned that I was called to the bar in 1996. I graduated in law from Queen's University, Belfast. And I would say that some of my tutors and professors in company law would be getting a solid chuckle, I think, at the concept of me having not excelled in company law, now trying to explain or trying to set out and present some concepts to a virtual room full of very experienced lawyers. So hopefully they never find out about it. But I'll start, if that's okay, with what I know best. And if Keith, would it be possible to put up the slides, and just the third slide in the slideshow, if at all possible. Okay, so if you just skip to the third slide, that'd be great. So Keith has specifically asked that I try to avoid death by PowerPoint as it's known, but just as an important way of getting sort of to the context of what we're doing here, I just want to show a section from the preamble, from the foreword of the Legal Services Regulation Act 2015. And this really sets out what the Act is meant to achieve. And there's two very popular misconceptions. The first is that the LSRA is only about the complaints function. And the second is that the Legal Services Regulation Act 2015 is only about the LSRA. Neither of which of those misconceptions are correct. So the LSRA actually has a very broad remit. And outside of the complaints function itself, you'll see that we're responsible for establishing the Legal Practitioners Disciplinary Tribunal. We have a research function in that we have conducted research and published significant reports on legal education and training. We do annual reports on admissions to the profession. At the moment, the Minister has asked us to conduct some research in relation to barriers to access to the profession. I wonder, sorry, Keith, could you flick back to that slide, just the one with the preamble on it, if at all possible? The LSRA also, you may or may not be aware, has responsibility for providing logistical and administrative support to the advisory committee on the grant of patent suppressants, which, as you know, relates to the grant of the title of senior counsel. And then one other piece of the role of the LSRA, besides the complaints, besides the research, besides the other things that we do, is the introduction of what's referred to in the preamble as new structures for the delivery of legal services. And what that refers to is the introduction of the authorization and framework for limited liability partnerships, but also the introduction of legal partnerships, the consideration of the introduction of multidisciplinary practices, whereby lawyers will be able to go into practice with other disciplines, such as accountants or architects. And another piece of research we have to do is to look at the introduction of the profession of conveyancer. So a very broad remit, not restricted to complaints. You'll also see that within the Legal Services Regulation Act, the creation of the legal costs adjudicator, the Office of Legal Costs Adjudicator, was also formulated. So much more than just the LSRA. And where all responsibility flows in relation to the new structures. Keith, if you just flick on to the next slide. So these are the six statutory, sorry, the back one, if that's okay. The six statutory objectives of the LSRA is really the lens through which we have to look at everything that we do. And I always think this is interesting for legal practitioners to hear if they haven't heard it already, because sometimes it comes as a bit of a surprise, because these six statutory objectives really relate back to the concept of balance, because you'll see that the LSRA has an objective to protect and promote the public interest, but also to support the proper and effective administration of justice. We have to protect and promote the interests of consumers, but to see as well, we have to promote competition and the provision of legal services in the state. And we also have an obligation to encourage an independent, strong and effective legal profession. And one of the main methodology by which we promote competition and provision of legal services in the state and encourage an independent, strong and effective legal profession is the introduction of these new structures, of which LLP really is the first. So I'm going to just talk you through what an LLP is and some of the other things. So if you want to, Keith, we can take off the slides for the time being, and I'll just go to camera, if that's okay. So I'm going to first point you to some resources before I hand over to Park. There is obviously the Legal Services Regulation Act 2015 itself, and Chapter 3 of that Act relates to LLPs and how they function. And then we issued a set of regulations which governs the application process and the register. They were issued in 2019. That's the Legal Services Regulation Act 2015, Limited Liability Partnership Section 130 regulations. It couldn't be as far from a catchy title as it could possibly be. And I'd also recommend probably the seminal text on partnership law, which is Twomey on Partnerships, Justice Twomey or Judge Twomey's second edition, which has a chapter on limited liability partnerships and explains the impact and the obligations extremely well. And also on our website, you'll be able to find there's an FAQ document, there's other guidance documents on our website at www.lsra.ie, which explains what an LLP is and some of the other stuff that's very relevant to the process and to the impact of being authorized as an LLP. So the simple question is, what is a limited liability partnership? As I said, introduced by Chapter 3 of the 2015 Act and Section 123 of the Act, which I'll read in full, states, A partner in a limited liability partnership shall not, by reason only of his or her being a partner or being held out as being a partner in that partnership, be personally liable, directly or indirectly, by way of contribution or otherwise, for any debts, obligations, or liabilities arising in contract, tort, or otherwise of the LLP, himself or herself, any other partner in the LLP, or any employee, agent, or representative of the LLP. And what that means in effect is that any relevant business, and by relevant business is defined under the Act as a partnership of solicitors, or ultimately a legal partnership, of which I'll explain more, can apply for authorization to operate with limited liability. So it doesn't apply to sole practitioners, and sole practitioners on their own cannot benefit from the limitation of liability under the Act. It has to be either a partnership of solicitors, or ultimately, whenever legal partnerships get introduced, a partnership between barristers or solicitors and barristers. And the limited liability partnership itself as an entity doesn't have limited liability. Instead, each partner in the LLP will not be personally liable for the debts, obligations, or liabilities of the LLP, himself or herself in the capacity of being a partner in the LLP, or any other partner in the LLP, or any employee, agent, or representative of the LLP. So in effect, it brings a shield around the personal assets of the partner, and they are not personally liable for the debts, obligations of the LLP. And the proposed benefits of this, and this was something the LLP status was something the Law Society and others such as the DSBA argued for and lobbied for a long period of time. And ultimately that saw fruition in it being incorporated within the 2015 Act. And it allows the risks to which partners are exposed to be better managed because they're not personally liable, their own personal assets aren't liable. And the intention was to increase competition in the marketplace and also potentially lead to a reduction in professional indemnity insurance in longer course. There are limits to limited liability, four really in reality. The first relates to the authorization date. Now, Park will talk you through the process, and one of the things I'll refer to is the date of authorization. So it's very key to when the limitation of liability actually becomes into play. So if a relevant debt, obligation, or liability arises from an act or omission of a partner, which precedes the date on which the authorization for limited liability status was granted, then the limitation is not available to the partner. So it's not retrospective, it doesn't look backwards. If the act or omission which creates the debt, obligation, or liability precedes the date of authorization, then you cannot rely on the limitation liability. It only flows from the authorization date, which comes from PORC in the authorization process. The second limitation is in relation to fraud or dishonesty. If the relevant debt, obligation, or liability arises from an act or omission which involves fraud or dishonesty by a partner, and either there's a finding of misconduct in relation to that partner under Part 6 of the 2015 Act, or if the partner is subject to a criminal conviction, then the limitation on liability will not apply to that partner. They can't rely on the limitation of liability where they've committed fraud. Also, the third limitation is referred to as unrelated purpose. So if the relevant debt, obligation, or liability was incurred by a partner in an LLP for a purpose that's not related to the business of the LLP, then that partner, again, cannot benefit from the limitation in liability. So if a partner in your law firm buys a horse or buys a racehorse using money of the LLP and creates a debt, obligation, or liability, they cannot then rely on the limitation of liability and their personal assets are in play should anyone seek to enforce the debt, obligation, or liability. And then the fourth exemption or sort of limited liability is tax. So you can't use limitation of liability to evade any tax obligations you may have. So if a debt or obligation relates to any tax within the meaning of Section 960A of the Taxes Consolidation Act 1997, then the limitation of liability will not apply to the relevant partner. It's not a methodology for evading tax obligations. There's also restrictions under the Act in relation to the property of the partnership. And it's quite complex under the Act, but in effect, you can't transfer property out of the partnership to a partner to become the personal property of a partner in order to avoid or evade obligations or debt. And the Act unpicks any attempts for which you do that. So Park will take you through the application process, but I just want to outline a couple of obligations very quickly in relation to your obligations once authorized. And really, this is the consumer protection piece. So the first obligation on the LLP is that it has to notify all clients and creditors of your new LLP status. And there's information prescribed under Regulation 5 of the Section 130 regulations I mentioned earlier on that outlines the information that you have to give to any clients and creditors about your new status as an authorized LLP. You have to maintain professional indemnity insurance, and for solicitor partnerships, that's PII that complies with any regulations made by the Law Society under Section 26 of the Solicitors Amendment Act 1994. And very importantly, if you fail to maintain professional indemnity insurance in line with that section, then your LLP status, your authorization to operate, is deemed to have been revoked. So if you don't maintain your PII, you can automatically lose your LLP status. You also have to conduct your business using a name that ends with either the letters LLP or the full title of limited liability partnership, and you have to use that name on all contracts, invoices, negotiable instruments, orders, advertisements, your website, publications, and that's to protect the consumer so they know that your liability is limited under the Act and you've been authorized to act with limited liability. Park will talk you through the register of LLPs, but the responsibility is on the authorized LLPs to make sure that that register of LLPs is up to date. So any changes in relation to partners, addresses, etc., you have to communicate to Park so he can amend the register. So very briefly, the story so far, as of this morning, I think there's 312 LLPs authorized and on the register that Park so diligently keeps. Later this year, we'll be introducing legal partnerships, which will allow for the first time solicitor-barrister partnerships and barrister-barrister partnership, which will be a new working model for the delivery of legal services. And once they are formulated as a partnership under partnership law in the state, they can also apply for limited liability. And following that, we'll then look to the examination as to whether multidisciplinary practices will be introduced in the states. And as I mentioned, we're doing a separate report on the introduction of the profession of conveyancer as to whether that should be introduced within the state. So I'm conscious of time. We've probably eaten in a minute or two into Parik's explanation as to the process. I would just say Parik and his team are here to help. If you have any questions or queries, or if you're considering applying and need some further information that's not available on our website, please feel free to reach out and contact either myself or Parik, and we'll do what we can to assist. Parik, I'll hand over to you.
Thank you, Brian. Afternoon, everyone. So as has been said already, my name is Padraig Langan. I'm the head of the Registration, Levy and Fees unit in the LSRA. And I run the team responsible for processing applications for LLP status and maintaining the register of limited liability partnerships. So the 3 points that I'm going to discuss primarily today are the application process for authorization as an LLP, membership alteration process, and the cessation notification process. Those are the 3 big issues for us when dealing with limited liability partnerships. So the first process obviously is applying for authorization as an LLP. And so interested partnerships as solicitors, the first step is to contact us via email and request an application form. It can be done by post, but as you know, emails is quicker, and the email address is lsra-limitedpartnerships@lsra.ie. And it's simply a one-line email requesting the form. And that day, or the following day, what we do is we allocate a unique reference number and we issue the form to you via email. And the email itself will contain the bank details for the LSRA for the payment of the application fee. It also includes some tips and reminders that will be useful when completing the application form. So the partnership solicitor completes the form, returns it, and they make the payment of the application fee of €175. And at that point, we start doing our checks of the form. So we do an initial check just to make sure that the details included on the form are correct. And we check that payment has been made and received. And so if everything on the form is fine and the fee has been paid, we issue an acknowledgement email. And this starts the timeline for our decision to be made not later than 60 days as per section 1259 of the Act. So we have 60 days in which to make a decision on the application. However, if there's some issues with some of the information provided, such as I'll refer on the next slide to recurring issues that we see with applications coming in. If there's small issues that we can deal with, we contact the applicant and we sort things out. If there's bigger issues, the form goes back and we request the applicant to resubmit it, fix it up and resubmit it. So once we send out the acknowledgement email, we start our processing, we do our verification checks. And once everything has been done and we're happy that we can move forward with the authorization, we contact the applicant and we check if they have a preferred authorization date. Some applicants need some time to prepare their branding and update their information and their branding. Others just want some time for the preparation of the notification to the clients and creditors. And we're happy to go with the preferred authorization date from the applicant. And once we receive that, we add the LLP's details to the register and we issue the email with the notification of the notice of authorization. And that is the decision issuing within the 60 days. And so that email goes to the applicant and confirms that they have been authorized, and the register is usually updated on the first Monday and the third Monday of each month. So with regard to the recurring issues that we see on application forms, we see occasionally that partnerships of solicitors use a different name than that which is registered with the Law Society. Now that may be as small as the word solicitors being included or submitted from the name, but on occasion we have got a completely different name, and so clarification has had to be requested. It slows down the process, as you can imagine. On occasion, a sole trader will become a partnership of solicitors. They'll be allocated a new firm number by the Law Society, and they'll include the old firm number on their application, and we just contact them and sort that one out. Sometimes there's typos with regard to the firm number and the solicitor numbers for a partner, but we contact the applicant immediately and we check what's going on. On occasion, we have found when we checked that a partner is actually still registered with another firm on the Law Society website. So we go back to the applicant, we ask them to update the details with the Law Society, their new company that they've joined and they're now partners with. On occasion, the Law Society haven't been informed that a solicitor is now a partner in the firm. So again, that's an issue that we ask the applicants to sort out. There are, with regard to missing signatures, there are signatures on page 2 and the second to last page of the form. Occasionally we'll find that these signatures have been missed, and we send the form back for the signatures to be added. And on occasion, people amend the statutory declaration. They cut out some of the text that they believe is not relevant, but in doing so, they take out some text that is relevant. So the form goes back to them at that point. And we have a warning on our webpage, and we have a reminder in the email going out with the application form to just be careful when dealing with the statutory declaration that we will have to send back the form if the declaration is incorrect. So once you are authorized as an LLP, you are required under the Act, under section 1263 of the Act, if you notice that there's an incorrect particular in your entry on the register, you have to inform us of the incorrect particular. So that might be something as small as a new phone number is needed, a new address. That's simply contact ourselves, let us know the change in the address, email, phone number, whatever it is. But if a new partner joins or a partner leaves, at that point, you're required to fill in a membership alteration form. And I'll just go through the process. It's a fairly simple process. You request the membership alteration form from the same email address LSRA-limitedpartnerships@lsra.ie. We send you out the form. You complete, return the form, pay the fee of prescribed fee of €65, and then once we get the form, we check the details are correct, check payment has been received, and if everything checks out, we update the register and we let you know that the change has been made. Similarly, if an LLP intends to cease operating as an LLP under Section 1291 of the Act, they're required to let us know that they are ceasing and the date that they intend to cease. There's a form, as with everything, there's a form to complete and return. Same process. You request the form through the email address. We'll issue the form the same day or the day after. You complete it, you return it, you pay the fee of €130, and then at that point we'll check everything is okay. We check payment has been made, and then we remove the details from the register on the cessation date and inform the LLP that the details have been removed. And just the last slide I'm going to show you now is just some further information. Brian alluded to it previously. We have a very good webpage on our website, which contains an information note regarding LLPs. It contains a kind of Q&A that you can drop down if you have a particular question. We're always available at the email address. I've said it several times, but I'll say it again, LSRA-limitedpartnerships@lsra.ie. Also, there was, we published an article in the April 2020 edition of the Gazette regarding LLPs, just giving a bit of background. There was a do's and don'ts on the application process. The link is there on the presentation if you need it. And I think time is tight as well, but I just say thank you for listening. Thank you very much.
Great. Thank you very much, Pádraig. Brian, is there anything further or anything that you wanted to say?
No, just to say thank you for having us and allowing us to deliver the presentation. Very much appreciate it.
Okay. I'll just stop that share. I'll just check that there's a question has come in, I believe here. Yes, can Pádraig clarify how an incorrect firm number is submitted?
Yes, I mean, I think it's the third field on the form. We sent out the form to people, and generally if somebody phones, I would go through and say, just make sure everything is okay on the form. And the field that comes back filled in by the applicant is F, and it's either 4 or 5-digit number. And once we check that detail, on occasion it has been incorrect. It might be something as small as a typo, or it might be a completely different number than what they are registered with and the number they have from the Law Society. So at that point, we either pick up the phone or we email them. Sometimes it's a quick thing. I used the previous sole trader number. I'll give you the correct number now. Or sometimes somebody says, no, that's my number, and we just have to contact the Law Society and clarify what the situation is there.
Great, thank you. There's another question as well, Pádraig. This is refers to a kind of perennial problem for a lot of legal practitioners. What happens in a two-partner LLP when one of the partners dies or retires? Is the LLP automatically deemed to be dissolved, deauthorized?
With regard to retirement, I suppose that's something you can anticipate. And the death, I'm afraid. Brian, do you want to advise on this?
I suppose the basic principle is that it has to be an existing partnership. There has to be a partnership in existence in order for to avail of the limited liability. So if you no longer are a partnership, you can't avail of limited liability under the authorization. And as Pádraig took everyone across, if it's anticipated it's going to be a cessation, then please inform us in advance as to the date, and we'll take you off the register. And if it's the unfortunate circumstances, if there's been a shock where someone has passed away, We'd also appreciate if you let us know, because there'll be an expectation that you're no longer able to avail of the limited liability.
Yeah, this is something that I think most solicitors would be familiar with, because the same rules apply. Within law society regulations, you cannot be a partnership unless you have at least two general partners. So, thank you.
And I would just note as well, Keith, that if there's a change in membership for us, a change in partners for us, there likely is for the law society as well. So you're having to contact the two bodies just to just to make sure people are reminded of that. If a partner leaves or a partner joins, there's two organizations, the regulator and the law society, both need to be informed of that.
Okay. Well, this has been really, really great. The numbers participating, attending are huge, and I guess that's a testament to, how an important a subject this is. Well, two subjects, the role of the LRSA and also limited partnerships. So thank you very much, Brian. Thank you very much, Pádraig. We're finishing up pretty much just on time, and thank you for that as well.
Our pleasure. Thank you so much.
If it's okay with you, we would like to send out the slides later in the week to people who participated. Is that okay?
Of course. Yeah.
Yes. Yeah,
great.
no problem.
Okay. Well, thank you both very, very much, and thank you.
Thank you.
Thank you.